On November 3, 1992, in Piscataway, Scott Johnson kidnapped Gail Scholler and her 3-year-old daughter. The crime began as a random carjacking. Johnson drove off with them in the victim's own car. Shortly thereafter, he abandoned the child in the dark of night at a closed daycare center. He next drove Miss Scholler to an isolated area behind a lumber yard where he sexually assaulted her and then savagely murdered her. Following this, he attempted to hide her body under several inches of water in a drainage ditch. An autopsy revealed that Gail Scholler had been stabbed over 40 times, including a slash wound on her throat. Early the following morning, her 3-year-old daughter was found alive, terrified, but otherwise physically unharmed near the daycare center. The horrific details of this crime stunned the Middlesex County community. The murder had all the elements of a suburban nightmare. A young, innocent mother and her daughter out on a family shopping errand are suddenly carjacked at random by a marauding criminal. The story remained front-page news for weeks. Following an intensive investigation, the defendant was indicted for murder, kidnapping, sexual assault, and related crimes. Apart from the sheer savagery of the crime, the facts and circumstances surrounding the offense provided the legal basis for the Middlesex County prosecutor to seek the death penalty under the New Jersey law in effect at that time. The one thing that all the attorneys involved in this case agreed upon is that given its monstrous facts, this particular prosecution would have been handled as a death penalty case by the prosecutors in any one of New Jersey's 21 counties. So the stage was set. Both the prosecution and defense were confronted with a high-profile case with a defendant on trial for his life. The following continuing legal education program will explore the complex tactics and strategies the prosecutor and defense attorneys in this case used to try the capital murder case of State of New Jersey versus Scott Johnson. Now, Part 1. The case for the prosecution.
Bob, when did you become a prosecutor in Middlesex County?
Back in 1992.
And so this case, I believe, occurred in late 1992 in November, so you had not been in office all that long when this occurred?
It was April of 92 when I was sworn in, so this was the end of that year, so it was only several months, 7 months.
Would you say this was the first big high-profile case that you had as prosecutor?
No, actually, about a month after I became prosecutor, we found a little his body.
Right.
And that was probably as high profile, if not more high profile, in this. It's still going on today.
Well, when did you first get involved in this case? In other words, when did you first find out that this had happened? My recollection was in early November of 1992.
Right. No, this was the first big case that I was actually involved in from its inception.
Right.
And I actually went out to Piscataway that night and was there. If you read the opinion, Tom Capsack was there.
Assistant prosecutor.
Yeah, Assistant Prosecutor Tom Capsack, who was in charge of our homicide unit and was an experienced and well-respected professional in that regard. But he was there. I was there. Several of the members of the homicide unit were there at Piscataway that night. Let's
walk through it. You got a telephone call that there's a homicide?
Exactly.
And what did they tell you, and what did you do?
Well, they said there's, at the time, we didn't know it was a homicide, but we did. It was, they found a child at the daycare center. The mother was reported missing by the father. And they told me those things, and that she had not, they didn't know where she was, and they didn't know where the van was that she was driving. So that's what I knew originally. I said, obviously, keep me advised at the time, and then they started their police work. They did a lot of canvassing, which led us to Scott Johnson. And once they brought Scott Johnson in, they called me and told me we're going to bring this guy in and we're going to do an investigative detention. And I said, well, hold on, let me go out to Piscataway and see what's going on. I was curious, number one. Number two, I was concerned.
So I take it then that what had happened in the early part of the investigation, that they really needed to examine him for forensic evidence. And I take it that they went to a judge of the Superior Court and got an order for temporary detention of him.
That's correct.
Took him into custody, but he wasn't under arrest in the technical sense. He was being brought back for investigative purposes.
Right. But it happened so quickly that at the time we brought him in for investigative detention, just about the time he arrived, we really had enough to arrest him. So
you had enough to establish probable cause at that point.
Exactly.
So he never made it out at that point?
No, he did not. No,
okay.
He did not.
Now, where was the investigation when you arrived over? I take it this was a joint investigation with your office and the Piscataway Police Department?
That's correct.
And at what point when you arrived at the Piscataway Police Department, what was happening at that point in the case? Had he been arrested at that point?
When I arrived, he was arrested. He was in a room with Chuck Clark, who was one of our, now retired, one of our experienced homicide detectives. Chuck was trying his best to find out what went on and question him. And we were discussing at the time also typing up the complaint against him to get that over to a judge, to have the judge sign it. And there we were. I was with Tom Capsack at the time, and we were waiting outside that room, which was behind closed doors, where Chuck was trying to find out what had happened.
Now, notwithstanding the fact that you're the county prosecutor and the chief law enforcement authority in the county, knowing you, I would assume you did nothing except let the professionals do their job.
Absolutely. Absolutely about that. I was only on the job like 6 or 7 months, but I was smart enough to know that by me taking control, we could blow this whole case. Right. So I did not.
Now, as things kind of piled up in the case, you had a confession, admissions, an enormous amount of forensic evidence. Really, the evidence of his guilt was very, very strong right from the beginning.
Overwhelming.